This is case number 22AP0019. Each party will have up to 15 minutes to present your argument. The appellant, of course, can reserve up to 5 minutes for rebuttal. I will be keeping track of time, so I'll let you know as you get close to your rebuttal time. The arguments, as I mentioned in the first oral argument, are recorded, so we ask that you stay at the podium, keep your voices up so we have a good record for the YouTube channel where these are posted. Judge Carr, Judge Hensel, and I have read the briefs, and we are prepared to proceed when you are. On behalf of the appellant, is it Attorney Flam?
Yes, Your Honor.
All right. How much time would you like to reserve, sir?
4 minutes, please.
4 minutes. And then I will let you know as you get close to that time.
Great, thank you. And may it please the court, Justin Flam on behalf of defendant, or excuse me, force of habit, I guess, there you go. On behalf of appellant, Burke, Hummel, who was the plaintiff in this case. The issue for the jury to decide is a relatively straightforward one on the facts of this case. Did his former employer, Hummel Group, in which Burke was a shareholder, breach the close corporation agreement that governed the shareholder relationship between Burke and Hummel Group? That shareholder agreement, close corporation agreement as it was captioned, was entered in 2013. It imposed specific requirements for any actions that would affect the employment status or the shareholder status of an employee shareholder like Burke. It required a 60% affirmative vote of all the shareholders, and according to the rest of that close corporation agreement, that had to be conducted pursuant to an agreement, pursuant to a meeting of the Hummel Group shareholders.
They did have take a vote at a regularly scheduled meeting, did they not?
At the end of August 2017, Your Honor, you're absolutely correct. They did finally put the matter to a vote. What is relevant here and what the jury needs to consider is what happened weeks in advance of that pro forma meeting. Because what happened at the end of July 27, it's clearly established as an undisputed fact in the record, Burke's boss, the president of Hummel Group, an individual named Von Troyer, had decided that Burke needed to go, that he didn't have a place at Hummel Group anymore. So he brought in the CEO of Hummel Group, an individual named Mike Summers, and in that July 27 meeting, they didn't talk to Burke about possibilities, they didn't talk to Burke about maybe this being put up for a vote. They told Burke he no longer had a place at Hummel Group. They said to him, and this is all established in the record evidence from the depositions of the other Hummel Group shareholders, that Burke, there's no place for you here. Lest that message be lost, and it was an unsubtle one to begin with, they met with him again, the president and CEO, his boss and the CEO of the company for which he worked, in which he was a shareholder. And in that meeting 4 days later, they underscored the message. He was going to be going out on a leave of absence. There is some fact dispute around whose idea that leave of absence was, but construing the evidence in favor of Burke as the non-moving party under the summary judgment motion on appeal here, the record shows that Burke was told to go on a leave of absence by his employer. Hummel Group said, take a leave of absence, take some time to figure it out. But what they didn't tell him is that in the interim, they were going to be taking that formal vote. And maybe to them it didn't matter. But this, again, is a jury issue, because what they were telling Burke, first at the end of July, then on the first day of August, well before any meeting had been held to consider Burke's employment or shareholder status, they told him flat out, you don't have a job here. When you come back from leave, there will be no role for you at Hummel Group. That is as clear a termination, being told by your boss, the president, and the CEO of the company at the same time, in the second meeting being held within the space of much less than a week, that you don't have a place at your employer anymore. That's the termination issue that the jury needs to consider, because at that point, none of the meetings had occurred, none of the votes had occurred, but there had been discussions amongst the shareholders. And this is yet another fact issue the jury needs to consider. The testimony of two other shareholders who did finally attend that meeting when it was put to that pro forma vote, they knew these conversations were going on. And President Troyer's own testimony makes clear that to his understanding, the other shareholders knew that that President Troyer and CEO Summers were telling Burke he was fired.
Counsel, of course, according to the deposition testimony and so forth, they were trying to negotiate Burke leaving, resigning. Or you don't dispute that, right?
They were hoping that he would resign. They were telling him, you don't have a place here anymore, Your Honor. It was not whether you will continue working here, though, it was how that separation is going to be effectuated. So you are correct in what they were hoping would happen. We're telling you, Burke, that you're not going to have a job here anymore when you come back from leave. That termination decision has been made, communicated to Burke, and then it's just a matter of the timing and a matter of how that's going to go. And what Hummel Group was hoping is that Burke, having heard this clear message from the president and the CEO, would take it upon himself to resign and make this a much easier situation for Hummel Group as an employer. But he declined.
Was it a situation where he was told you don't have a place with the company, you're going to be terminated, as opposed to you are terminated? You see the difference?
I do. I think the record evidence, Your Honor, is very clear, even without construing it in Burke's favor, as we have to do here on summary judgment. If you read the testimony itself, what it says is there's not a place for you here. There is no role for you here.
But after those conversations, was he still active in the company?
He went out on leave shortly thereafter.
And he was paid?
Yeah, that was paid leave, that's correct. Even when they had the formal vote at the end of that month, it was not until September 1 that they issued him a letter. Even that termination date was set out for October 1st. So even their position is, we terminated him at that meeting at the end of August. We issued him a September 1 letter, but even that September 1 letter says, you're not terminated yet, you're terminated on October 1. If you move that back one step in the logical order of things, Your Honor, that's the same thing that they did to Burke in those meetings. They hadn't had the meeting yet. What they had been doing was talking to all the other shareholders, such that when they went in for that formalistic meeting at the end of August 2017, the other shareholders knew. This was not a surprise to any of the shareholders, what the evidence very clearly says. And one of those shareholders said, we walked into this meeting knowing that this was a unanimous thing, an agreed upon thing. They'd been having these conversations with the shareholders prior to a meeting saying, we need to get rid of Burke. And the rest of the shareholders either knew or at least understood that Summers and Troyer were having those conversations, conveying that message to Burke. So I take your point, but I think Hummel Group's own position rebuts that point. It's not a question of when the termination would become effective, it's when was it decided and then communicated to the individual who was affected by that.
But until there's a formal vote, any of those shareholders could have changed their minds, right?
In theory, they could have, Your Honor. However, this was understood to be a unanimous and agreed upon thing, as David Taylor's testimony for one. But secondly, the genie is already out of the bottle. They've told Burke, you don't have a job here anymore. So whatever change of heart any shareholders may have had, it's already been communicated to Burke. You can't unring that bell just by having one shareholder come up and say, well, I've rethought this and I've changed my mind. That communication has already been made to the affected individual.
I understand, but I'm trying to figure this out. But if a shareholder changed his or her mind, and of course Burke was a shareholder as well, then whatever they told them wouldn't be effective, right? Wouldn't be enforceable.
I would submit that that's a jury question. When you tell an individual your employment is ending and you don't have a place here anymore, is that sufficient to constitute a termination of employment? I would submit that as a question the jury in this case needs to consider. Construing the evidence here most favorably for Burke, I think it is a fair interpretation to say your boss and the CEO of the company, and by the way, a week later, 10 days later, they had the treasurer, Dave Coyle, meet with Burke and just underscore the message yet again. 3 separate meetings with the top leadership of Hummel Group. That's a termination. Regardless of what might have happened down the road, that was the termination. It was just a question of whether, or excuse me, not a question of whether, it was just a question of when and how, the how being would Burke do a favor to them and resign instead of going through with the course that they had already set about. Those are the jury questions on the facts, Your Honor. We have a bit of what I consider to be a distraction in this case in the form of a statute of limitations argument under a completely separate agreement. The close corporation agreement was executed in 2013. 2 years later, Hummel Group presented Burke with an employment agreement in 2015. That employment agreement had a rather curious provision saying you have 180 days if you want to raise any claims arising from this employment agreement. And that's the key language on this contractual statute of limitations argument. It does not anywhere in that employment agreement refer to the close corporation agreement. It does not even have the same parties. It does not purport to say in the employment agreement that all claims you may have against Hummel Group have to be brought within 180 days. They could have easily done that. They wrote this agreement. They could have easily said in 2015, we're having Burke sign a new contract that's going to pull in whatever claims he may have, whether it's based on this contract or the earlier contract we've already signed or anything else. But they didn't do it. They wrote a narrow provision. And the cases that both parties have cited are quite clear that when a contract is unambiguous, it is the words of that contract that define what the parties agreed to. What the parties agreed to when Burke and Hummel Group signed that 2015 employment agreement is that if he was raising a claim under the employment agreement, he would only have 180 days to do that. He's not raising claims under the employment agreement. There's nothing in that employment agreement that speaks to the supermajority requirements, that speaks to meeting requirements as the close corporation agreement does. It would be an unprecedented extension of a contractual provision to say this 2015 document somehow applies back to an earlier agreement which it does not reference and somehow causes that to have an effect that Burke never would have contemplated. The Supreme Court's decision in the Barbie case makes clear that a contractual waiver of any kind of statute of limitations provided by law has to be in a contract that is very clear and unambiguous, meaning that the party would have to understand what that person was signing. No party signing that. You'll see in the brief references to Burke's college education, his business career, and so forth. No party signing an agreement that says claims arising under this contract I'm signing today are going to affect claims that are explicitly under the very detailed and unique provisions of a contract that we executed 2 years ago. The statute of limitations argument is a red herring. This case rises and falls on its facts. And those are facts that the jury should be permitted to consider with respect to this termination. Look at the shareholder testimony. Look at Derek Hummel's testimony, Burke's cousin. He said that this decision had been made and conveyed to Burke, is what Derek Hummel testified to. David Taylor, the other shareholder I alluded to, his testimony is in the record and in the briefs. David Taylor said, we didn't just walk in there one day and do this. This was a unanimous thing. So what Hummel Group did with its close corporation agreement was purport to say you can't bring fiduciary duty, breach of good faith claims. And there is Ohio case law supporting the notion that you can waive that via contract. What it did say is before we terminate somebody, here's what we're going to do. And they didn't do that.
Counsel, this argument is very interesting, so I lost track of time. We're down to 3 minutes for your rebuttal.
Okay.
So
Thank you.
you either continue or reserve.
I will reserve. Thank you, Jim.
All right, thank you very much. You, counsel, you'll have 15 minutes unless I get, caught up in your argument as well.
Do a little song and dance and try to distract you here.
So 15 minutes for you, sir.
All right, thank you very much. Good morning, Your Honors. I'm Leslie Newhouse. I am counsel for App.No, Hummel Group Incorporated, HDI. There are no disputes of material fact in this case. In fact, when you read appellant's brief and you look at the deposition testimony that's cited in it, it illustrates very well just how hard the shareholders of HDI worked for the purpose of addressing a very serious problem. For years, Burke Hummel had been an inferior, unproductive employee who had failed in one assignment after another. He acknowledged in his meeting with David Coyle that, but for the fact that he had the Hummel machine, he would not have been employed there for as long as he had been. Problems came to a head in the summer of 2017 when an employee in the same department was terminated because of his lack of productivity, inferior work product, absenteeism, and falsification of information about in that summer, in June of 2017, the company terminated that employee. And another employee in that same department came forward and said, hey, there's a shareholder that works in our department that has the same problems as the person you just terminated. He came to David Coyle to tell him that. Mr. Coyle, who was the treasurer, went to Mr. Troyer, who was the president, and they determined they needed to investigate the complaint that they had received from this employee. They did conduct that investigation. There's no dispute about that. What they found in the investigation was far worse than what they anticipated. They found things, and again, these are undisputed facts. Mr. Hummel didn't dispute them in his deposition, and there's been no argument in respect to these facts in any of the briefing, either in the court below or here. The facts are that Burke Hummel had engaged not only in very poor, shoddy work performance, but also dishonesty. He had forged names on documents. He had lied to his shareholders. He was of the habit of viewing pornographic websites on the company computers, contrary to company policy. And the shareholders had come to him and said, don't do this anymore. And he said, it'll never happen again. And he admitted in his deposition that he had lied to the shareholders.
Counsel,
about his doing that.
but the real issue here is not so much whether there was merit to his dismissal as the procedural process.
That's right, Your Honor, and let me address that then. So they conduct this investigation, and they do what responsible owners of a company must do. They went to the shareholder who was the cause of the problem. And they had 4, not 3, they had 4 meetings with him where they told him, here's what we found. These are very serious problems. We would like you to resign. And they even discussed with him the amount that he would receive, the very considerable amount he would receive if he did resign because of the buyout of his shares. So there was ongoing discussion of his poor work performance, of the desire of the shareholders that he resign voluntarily. And they even got into the discussion of how much he might receive if he did leave and there was a buyout of his shares. That was what was going on in the summer of 2017, and that's not disputed. The shareholders were acting as agents for the company in investigating and in discussing both with Mr. Hummel and also among themselves the very serious problem that they had. But those shareholders all recognized the limits of their authority, of their agency. It was their duty to investigate and to address these issues. It was their duty then, under the close cooperation agreement, to take action in respect to his ongoing employment. None of the shareholders terminated Burke Hummel's employment. They discussed with him the fact that there was no place for him at the company, that they wanted him to resign. But none of them terminated him, and all of them testified that they didn't have the authority to do that. According to paragraph 4B of the close cooperation agreement, that termination could take place only when the shareholders met and voted. That's what they did. On August 29 of 2017, a meeting for which Burke Hummel had notice, as all of them did, it was a standard monthly meeting of the shareholders. The calendar on his computer showed that he had notice of it. He testified that he had notice of it.
Counsel, when you
Yes.
say he had notice, you said it's a standard monthly meeting, so he had notice of the shareholders meeting that's held monthly, or did he have notice that his employment was going to be discussed as to whether or not he would be terminated at that meeting?
Von Troyer testified that he didn't tell him outright that we're going to vote on your termination at the meeting.
So he didn't have notice?
Well, he had notice certainly of the meeting, and there had been 4 in-depth discussions with him in the prior month about his poor work performance and the desire that he
And at those meetings, did they say to him, now, if you choose not to resign at the next monthly shareholders meeting, we're going to ask the shareholders to vote to terminate you?
No, they didn't. They didn't say that, Your Honor. The situation there, though, is much like what the court found or dealt with in the Coos versus Central Ohio cellular case. That was another case where there was a standing shareholder meeting for which all the shareholders had notice. But there was no specific notice given to the 2 shareholders who were dissenters as to the subject matter that was going to be voted on at that particular meeting. But the court said that this is a closely held company, and these shareholders had been discussing this topic for weeks prior to the meeting. So although there wasn't specific notification as to the subject matter for the meeting that was given to these individuals, they were still deemed to have had sufficient notice of the subject matter of the meeting and of the meeting itself. That's the same case here. I mean, there were those 4 meetings where they had explicitly discussed, and one of them lasted 2.5 hours, where David Coyle went through all of the detailed information found in the investigation to make sure that Burke Hummel knew what the issues were. Burke Hummel was certainly given notice that his employment was on thin ice, that his termination, if he didn't resign, was going to be a matter under consideration for the company. So the company took these measures, the shareholders took these measures, and then they recognized the limit of their authority. They did not terminate him. They had a shareholder meeting. They voted 87% of the ownership interest, that is every single one of the shareholders, voted in favor of termination. That fulfilled all obligations on the part of the single defendant, in this case, the corporation, in respect to the termination of employment. What the shareholders thought on their own opinions, their own discussions amongst themselves, that's not the issue here. The material facts are that the sole corporate defendant fulfilled the obligations, the express obligations of the close corporation agreement. And as a consequence, Burke Hummel's termination from employment was not a breach of contract, and the trial court properly found in favor of HGI in respect to that matter. The appellant raised an issue in their reply brief that hadn't been raised ever before, so we didn't get a chance to brief it. But it's the doctrine of ratification. Well, if those shareholders acted outside the scope of their authority, and they took the bull by the horns and they terminated Burke Hummel without a vote, well, that was cured on August 29th of 2017, when the shareholders met, when they voted, when they fulfilled the obligations of the close corporation agreement. We didn't raise the issue of ratification ourselves because we believe that the shareholders did act within their authority. They didn't do anything in excess of what their agency required. And the appellant is the first to have raised that issue in the reply brief. Now that they've raised it, that issue is favorable for HGI because the shareholders did act. They did vote. They did adopt the actions that were taken by the shareholders prior to that meeting, and that constitutes ratification, which cures the alleged deficiencies in the actions of the agents. I'd like to address briefly the time limitation issue, and that is if you read Section 17.01 of the employment agreement entered into in September of 2015, in that section, there is the statement relied upon by Mr. Hummel that termination pursuant to the terms of this agreement appellant hangs his hat on that language. But you have to then read the next phrase. The next phrase then defines what is a termination under the agreement, the employment agreement. It says, including any claim or cause of action that disputes or is based upon a termination of employment. So that next phrase defines any claim for termination as being a claim arising under the terms of the employment agreement. It's plain, it's simple, it's direct, it's unambiguous, and what's more, if you look at the testimony of Burke Hummel, he understood it to say that. Pages 52 and 53 of his deposition. Mr. Hummel is asked the question, well, you understood that that 180 days applied to your termination. And he said, yes, he understood that. Well, the question is whether the language is plain and unambiguous, and when the person himself testifies that he understood, then that's surely an example of how plain and clear that language is. Further,
Counsel, let me just stop you there. If Mr. Hummel said, I thought that applied to my employment, isn't that really an issue of law, though? It doesn't really matter what he thinks?
if there is ambiguity, Your Honor, then there is a question of law regarding the meaning of the term, and that is for the court to decide. But if the language is plain and clear and unambiguous, then the language must be enforced as it's written. And that's the case here. And as an example, in the Barbie case, in the Sarmiento case, that was one of the leading cases in respect to the enforceability of a contractual time limitation. And in that case, the court said that the language must be clear and unambiguous to the policy holder. All right. Well, in this case, the policy holder is Mr. Hummel, right? And he understood it. He knew what it meant.
But that's my whole point. Either it means this, or it doesn't. It doesn't really matter what he thinks it means.
Well,
Because you're alleging it's clear and unambiguous, so what's it matter what he thinks?
the point is that he understood it
Okay.
to mean that. And that's simply that, Your Honor. He was also represented by counsel. I mean, he had been represented by counsel since a few days after he received the September 1st letter. Certainly he was in a position to know it, to understand that that time applied to him, and he needed to conform to it. The time must also be reasonable. And an example of case authority that addresses the reasonableness of the time limitation of this nature is in the Fry versus FCA case, a decision from the 6th District from 2017. And in that case, the court enforced a contractual time limitation for an employment claim that was 6 months in duration, the same as this.
Counsel, you are at your 15 minutes.
Very good. Thank you, Your Honors. We believe that the trial court properly granted summary judgment in this case, and we would ask that the court affirm. Thank you very much.
Thank you as well. Counsel, you'll have 3 minutes.
Thank you, Your Honor. I'd like to touch briefly on the contractual statute of limitations argument that was closing topic there. Judge Carr, your questions got to the heart of the matter, really, as far as the damage to Burke, the harm to Burke. And that is the merits of this case didn't get considered there. He didn't have a chance to consider that because of all this going on. Excuse me, I'm taking that slightly out of order, though. So the language in the employment agreement doesn't say what Hummel Group wishes it said, that including clause that Mr. Newhouse referenced does not bear the weight that he would put on it. What it says is anything arising out of the terms of this agreement. It doesn't say out of your employment. And you can look at the Fry versus FCA case that we closed on there. And what that was a provision limiting a statute of limitations in an employment application. And the language there was very clear. Any dispute over your employment has to be brought within this certain shortened period of time. That's not what we have here. We have the contract very clearly stating it only applies to terms under the employment agreement, and there are no such claims here. There are no terms of the employment agreement at issue. It would be a dramatic overreach to take that employment agreement, which says this 180-day clause only applies to this contract, including these kinds of claims, but only such claims under this contract, and reach back 2 years prior to another agreement that has drastically different terms. That argument is a red herring to prevent the court's focus on the merits. The merits of this case, as developed in the factual record, are what the jury needs to hear. And I thought Mr. Newhouse's argument really put the yellow highlight and the exclamation point on some of that in response to questions from the bench on that. It wasn't so much that this meeting in August, the formal board meeting, was the important part, according to Hummel Group's own counsel. It was they'd had these multiple in-depth meetings prior to that. And that's where the termination occurred. That's where the termination was conveyed to Burke Hummel in no uncertain terms by 3 of the top executives of the company. The notion of ratification, I would respectfully disagree that that was raised for the first time in the reply brief in some new kind of way, but really we're talking about 2 different kinds of ratification. I think if you look at the Campbell case, which is discussed in the reply brief, Campbell versus Motor Inn's Hospitality, that was a contract signed by an executive of the defendant company in that case, an employment agreement, providing certain benefits. It was not approved by the board of the employer, but it was signed, countersigned by both the executive and then someone acting, or at least purporting to act on behalf of the company. What the Campbell case says, according to the Ohio Supreme Court's take on this, is you don't need to have those corporate formalities. There isn't going to be necessarily some formal ratification subject to meetings and notice and all those kinds of things. There was no such ratification, in fact, in the Campbell case. It was never ratified. Somebody at the board level in the Campbell facts figured out that this agreement had been executed and that they had in fact been paying Mr. Campbell under those terms, and all of a sudden said, whoa, the board didn't actually authorize this agreement, so we don't have to honor this agreement. And the Ohio Supreme Court said that's not the law. You ratified it by your conduct. That is what we have here. The conduct was telling Burke, whether it was their opinion or otherwise, the explicit testimony from Mr. Troyer, from Mr. Summers, is that they were acting in their official capacities as executives of Hummel Group when they did that.
Thank you, counsel. You've used your rebuttal time.
Thank you, Your Honor.
Well, very interesting arguments. We'll take the matter under advisement, issue a decision in due course. Each of you will receive a copy of the court's decision from the clerks. On the day it's received, it'll be mailed to you, and the opinions are also posted on the Supreme Court of Ohio's websites. Again, on behalf of Judge Carr and Judge Hensel, I want to thank you for your appearance today and the excellent arguments.